The circumstances of your injuries, what was passed over to the hospital when you came in, your partner said that you were play fighting. Is that true? No. Okay. Okay. Has he purposefully hurt you? Yes. Okay. Okay. Has he hit you? Has he pushed you? Okay. Okay. And you feel like he's hurt you on purpose? Okay. Has he ever hurt you before? Okay. This isn't the first time. Are you scared of him? A little bit.
We've had an allegation of an assault that's taken part against your partner. So at this moment in time, 23:37, you're under arrest for Section 18 wounding. Alright, so you don't have to say anything, but in my own defence, you mention when questioned something which you're later on in court. Anything you do say may be given evidence. Alright.
Ambulance service. Is the patient breathing?
Yes, patient's breathing.
And is the patient awake?
But she can't feel her body. It feels numb.
Okay, is she awake at the moment?
She's awake, yes.
Okay, just tell me exactly what's happened.
She's just had an accident, and she just can't move. She's laid in bed now straight, but she can't feel stuff.
How is it that she's hurt herself?
She's fallen out of bed.
She's fallen out of bed, okay.
And she's just landed in a bad way with your neck. Hello?
Hi, was it you that made the original call?
Yes.
So what's going on then? Because obviously we're getting two stories here.
What's the two stories that you have?
So we've been told that she'd fallen up the stairs last night.
No, I didn't. I never said that. I never said that she's fallen up the stairs last night. I never said that.
Right, so that's the details we've got in the initial call, is that she fell up the stairs last night, went to bed, and then has developed these symptoms since.
We was mollycoddling upstairs.
Oh right, okay.
And this tragedy has happened.
Right,
I was
okay.
too distraught. If that's come across, I was too distraught. I don't know.
It's perhaps the hallmark of a sophisticated abuser to intersperse violence and cruelty with false kindness and care. Your behaviour was so extreme and confusing that, as you intended, you led this intelligent and articulate woman to doubt her own experiences. We see those thought processes in the Apple notes which she wrote to herself. It is a chilling insight into your manipulation and control of her. The two assaults to which you pleaded guilty were particularly serious. Count 1 concerns an incident in an Airbnb when, after an argument, you launched an unprovoked and deliberate attack upon Miss Burgess when she was on the bed. You wrapped her head in a bedsheet so that she was unable to breathe. The next day, she was still suffering from a sore throat. Count 2 occurred in the January of 2025. You'd been out for dinner with friends. On the way home, Miss Burgess complained that they couldn't host friends at your house as you had insufficient cutlery and crockery. It was a feature of your controlling behaviour that whilst you made it clear that you resented her maintaining her own property, you would not let her buy anything for your property so that it might be a home to her. And as a result of that comment, you lost your temper and drove at excessive speeds, frightening Miss Burgess before bringing the car to a sharp stop. You then headbutted her and dragged your stubble down her face, causing grazing injuries to her face. She fled the car on foot to get away from you. All of this was the background to the circumstances of the brutal and life-changing assault which you subjected her to on the 17th of February 2025. She had been staying at your house and had slept in your spare room. You were due to go to work. The relationship had become such that she'd resolved to end it. You took her a cup of tea, and she said that because of how the relationship was, she no longer wanted to be there. You, as was your habit, turned it back on her. You accused her of always making things difficult. At one point, you put your fist to her face, such that she feared an immediate assault, and she begged you not to hurt her. As a result of this bullying, she backed down and said that she would stay, but you were already in a rage. You went back downstairs and raged on, and because of your behaviour, she felt that she couldn't safely leave the house. You then came back up the stairs, you pulled her down the bed towards the foot of the bed where you stood and she was kneeling. You then placed your hands on her head and pushed down with all your strength. You were shouting over and over at her. No sentence I can pass upon you could begin to equal the harm that you have caused. I must pass the sentence which I consider to be just and lawful. But the fact remains that even with the lengthy sentence I am about to impose, you will have a prospect of a future which you have denied to your victim. I'm required to consider whether there is a significant risk of you causing serious harm by the commission of further specified offences. You're 57. You have one previous conviction for causing grievous bodily harm in 1990 when you were 21, for which you were fined by the Clitheroe Magistrates Court. You didn't give evidence at your trial on this matter. The account you gave to the police was that this horrific injury was caused during what you described as play fighting. That was plainly false. Indeed, during the trial, it was not put forward as a possible mechanism for the injury and must have been false given your plea to the lesser offence. To the author of the pre-sentence report, you have chosen to give an equally fanciful and dishonest account, which is quite different to the one you gave to the police. It's perhaps a measure of your refusal to accept responsibility that you deny to the author of the pre-sentence report being guilty of controlling or coercive behaviour, even though you pleaded guilty to that very offence. The author of the pre-sentence report describes your account as evasive. I go further. It's just dishonest. Your inability to accept even that which you have already admitted makes you more dangerous. You are not capable of change until you accept that you need to change. I take into account your sense of entitlement. On your account to the author of the pre-sentence report, that day Miss Burgess said she wouldn't be at home that evening to make your evening meal, and that irritated you, you say. As the author of the pre-sentence report points out, you failed to see or to understand that she had a life of her own, separate from the life with you. I must also place this incident in the context of the other offences of violence and also of the coercive or controlling behaviour within the relationship. The author of the pre-sentence report notes that using a particular tool to assess your risk of reconviction, the risk is assessed as being low. The author of the pre-sentence report does not agree with that assessment. Instead, they assess the risk of you causing serious harm as very high, especially to intimate partners, particularly whilst you don't accept responsibility for what you've done. You're said to be at medium risk of serious harm to members of your own family. I am satisfied that you are at significant risk of causing serious harm to other people by the commission of further offences. This is not a case where a life sentence is called for. However, I am satisfied that an extended determinate sentence is required in order to protect the public from you. Given the length of the sentence I'm about to impose, you would not be released until 2/3 through your sentence, even if a determinate sentence were imposed. However, public protection requires the additional protection of the review of your release by the parole board and an extended licence. Once released, you may form another relationship. That will be a highly dangerous situation, extended oversight is plainly necessary. Stand up, Robert Easom. The sentence after trial on count 1, assault occasioning actual bodily harm, would have been 20 months. With credit of 15%, that gives a sentence of 17 months imprisonment. The sentence on count 2, again assault occasioning actual bodily harm, would have been 40 weeks. With credit of 15%, that gives a sentence of 34 weeks. The sentence after trial on count 5, controlling or coercive behaviour, would have been 3 years. With 10% credit, that gives a sentence of 32 months. The sentence on count 3 for inflicting grievous bodily harm with intent is an extended determinate sentence of 20 years, total duration comprising 16 years custodial element and an extended sentence of 4 years. All sentences will run concurrently with each other. Sit down, please. The extended sentence is made up of 2 parts, a custodial period, which will be no longer than the 16-year period I mentioned, and an extended licence period of 4 years, making an extended sentence of 20 years duration in total. You'll serve 2/3 of the custodial period in prison before the parole board will consider whether it's safe to release you, and if so, on what terms. Once released, you'll serve on licence any part of the custodial period which remains, and you'll then be subject to an extended licence for a further period of 4 years, making 20 years in all. When you're subject to licence, you commit another offence or fail to comply with the terms of your release, you are liable to be recalled to custody and may serve the entire 20-year sentence in custody. The days you've spent on remand will count automatically towards the custodial term of your sentence. Would you go with the dock officer now?